All right, hello. I know that I can see plenty of you are joining us now. We're just going to wait for everybody to join over the next couple of minutes. I appreciate that there are quite a lot of you who are trying to access this seminar this evening, so we're just going to wait. You should be able to see on your screen a PowerPoint presentation. Just to introduce ourselves to you this evening, I'm Alice Coverley. I'm a barrister practicing at 3PB Buildings in London, and I'm part of a team of education law barristers who specialise in all things to do with education of children and young people and adults. The work that I do is predominantly in relation to children with special educational needs, as well as in respect of children's safeguarding and sexual abuse claims and Equality Act related difficulties. I also act for schools as well as government departments, and I acted for Ofsted for many years on its independent inquiry into child sex abuse. So I hopefully able to give you some interesting insight this evening if we haven't spoken to each other before. I'm joined and actually privileged to be joined by Polly Kerr, who's a partner and the head of the education team at Simpson Millar, which is a public law a firm that specialises in education law and is well used to challenging different organisations in respect of children and young people's special educational needs, both from the kind of first tier tribunal perspective and also from the public law perspective, so through judicial review challenges. And they also, and Polly, you'll correct me if I'm wrong, work closely with schools as well and provide all kinds of strategic advice to different clients in different areas of education. So in terms of what we're going to talk about, firstly, we're going to hopefully tell you what the reforms say. We're also going to have a look at why we think that the government is introducing these changes or proposals. We're also looking at the when the reforms are likely to be implemented, or when we're going to start to feel the ramifications of those reforms. Perhaps almost instantly in some cases, but perhaps not for a long time for others. And then probably most importantly to the lawyers and no doubt many other worried individuals in the room, how will it work? Will it work? We'll also look at that. Over to you, Polly.
Thanks. Yeah, welcome to our rapid review of the SEND white paper. We've got a huge delegate list, which, as Alice said, we're really, really pleased with, and it's very, very diverse. So the first thing we wanted to do was be really clear on where we're at today, because we've had a lot of questions through in advance from parents, from parent representatives, about what happens with a plan now. And the answer to that is nothing. Nothing changes today. So the white paper is not law, and that's really important to stress. It is the government setting out their proposals, so setting out what they are planning to do, subject to consultation, which has come out at the same time, to change the SEN process, to change education for our young people. But young people that have EHCPs today keep their EHCPs today, and nothing's going to change for them for the foreseeable future, actually. So we worked it out as per the proposals at the moment, that we think if you are in year 4 currently, so that's 9 to 10 years old with an EHCP, if the trajectory set out in the white paper continues in the way it's set out, then you should get to the end of year 11 before you see that review of your plan and that reassessment. So you should actually get through compulsory education with your EHCP intact. Now, that's not to say that those dates won't change, but that's what it looks like at the moment. So, for example, for a year 9 student going into GCSE years in September, which we have had an inquiry about specifically, nothing should change for that young person. They've got their EHCP, that should continue. We will also, in addition to having an EHCP, none of the rights that come along with that currently are changing as yet. So the enforceability of Section F, for example, Section 42 of the Children and Families Act, that hasn't been repealed by a white paper, that still remains in force. If a young person isn't receiving the provision in their plan, they can continue to challenge that. If decisions are made by local authorities not to assess, not to issue an EHCP, or around the content or placement, that's still challengeable to tribunal. So we just wanted to stress that at the start, because that is actually something which underpins a lot of what we've seen online and also a lot of the questions that we've had come in. So yeah, just to pick up as well, section 19 education. So we see a lot of young people who can't attend school at the moment because of permanent exclusion, illness or otherwise. There's no proposal for that to change. And certainly I haven't seen anything actually in the white paper that addresses this at all, quite frankly. So any young person that can't attend school because they're too unwell for an extended period of time, or for other reasons, or because they're permanently excluded, that remains as is as well. And the first tier tribunal, we'll come on to them much later in the presentation, but at present, all of that remains the same.
It all remains the same, but however, Polly, you were saying, and I've seen other professionals who have received correspondence from local authorities that says things like, in the spirit of the reforms, we will not be agreeing to assess in the circumstances. And I think that it's not just one person I have seen who has said that. I haven't seen that firsthand, but I know that there are solicitors who I work with who have seen those letters. I also think it's probably fair to say that we will see the ramifications of a cash injection into schools on this system. Absolutely. That will impact the questions that we ask day to day about what is reasonably required in a school and whether or not a young person reaches the threshold of an EHCP. So it will impact it in that sense, I think. But for those children and young people who already have EHCPs, I think that they can hopefully feel a little bit more reassured about those EHCPs remaining in place. But I can see that there will be some. I can see that there will be some concerns on the horizon. And the reason we're saying that these legal frameworks stay the same now is that these rules haven't changed. There's no legislation on the horizon immediately to amend the Children and Families Act. There's also no legislation that has been posted yet to mean that an EHCP can't be enforced by way of, for example, judicial review or challenging the contents that way. Also, as Polly said, you can still say to a local authority, you are failing to put into place suitable alternative provision for my child who is out of education. Those rules stay the same, but the thresholds may well evolve in circumstances where resources change and where advice changes and where expertise, ideally in the government's mindset, increases in quality. So that's where we say the but. So everything does stay the same, but there may well be an evolution in terms of thresholds for support changing slightly over time in the immediate term. So what we have set up on this side is there's quite a lot to read and to get through. We've done our best to read everything so far. And the headline is that there is a policy paper, but there is also a consultation about what they want to do. And you have to read all of these things together to really get an idea about what exactly the government wants to do and why. And even then there are some question marks about it. We also actually highly recommend having a look at the easy read version of the guide of the document, that the government has issued. And the reason for that is because it often then cuts out some of the fluff around what they're actually saying and gives quite a clear idea of actually what's being changed. It can, on the other hand, oversimplify things and ask and raise more questions on what exactly needs to be done differently. But we have seen that for the first time in a while, actually, we've seen the easy read and the large print, and everything else comes out at the same time as this, which is very helpful. So do make sure that you, in time, have a look through these. But we'll of course explain these to you now. So Polly and I have seen, in terms of a summary of the reforms, that in effect, what the government is saying is that pupils' special educational needs should now generally be met through a new and layered system of support. EHCPs will be reserved for only the most complex cases, only the most complex and severe cases. So schools will then be tasked with meeting these new inclusion standards and new duties to ensure that they are meeting the needs of children with special educational needs. So we will see new inclusion standards published. and a duty on schools to create inclusion strategies. And being able to reach these standards will come by, we are told, a large funding injection into these mainstream schools. There will also be, taking language from the local offer, a universal offer for all children. And that new system will start with that. And in effect, this is what I mean when I'm talking about everything legally currently stays the same, but the baseline shifts, arguably, because there will then be a new baseline of what we should reasonably be expecting to be available in mainstream schools generally for children with special educational needs. That the Department for Education is expecting that most children will have their needs met generally in mainstream schools. And they're doing that by saying the universal offer will include more training for staff, but there'll also be better and more evidence-based support and strong partnership. And we'll talk about the different ways in which the government suggests that that will happen. But that's what I mean when I'm talking about the baseline for what should ordinarily be in mainstream schools is apparently going to be raised. And so that will mean that where in the past it may have been more difficult to expect a school to have, for example, technology to support children with special educational needs that might ordinarily be a bit more expensive, and therefore you need the ACP to get, that may well be part of what is standard and available in all schools generally, with an increased budget given to those schools. And so the need for an EHCP to secure that type of provision arguably falls away. And so that may also mean a more embedded approach to occupational therapy, for example, or communication and interaction support from the speech and language therapist is part of the general fabric of a mainstream school environment. So we have a but though here with the funding injection part. So Polly, what did you want to say about the but?
So 4 billion as it stands sounds like a massive figure when you say £4 billion. But when you think about how long it's going to be spread over, how many schools and young people there are, and the fact that the Office of National Statistics has already identified 6 billion as being the figure that is needed, we're already 2 billion short. But also, Alice and I were talking around this earlier, and yes, this funding can go in now. And what we may well see straight off the bat is that children are seeing better provision in schools straight away. So even though the law hasn't changed, if the funding goes in and therefore needs can be met within the usual funding of a state maintained school, then young people may well find that their need for an EHCP is lessened automatically because that additional funding is there, arguably. What we don't know is how long that additional funding is going to last, because we've got this figure of 4 billion and we've got this plan to put in place all of these ISPs, and which we'll go into later on. But if that funding is injected now for the young people now and doesn't continue, or does continue at that level but is not increased, so therefore goes down with inflation, the situation we're going to have is actually that initial funding, yes, it looks great on paper, but it doesn't then feed into schools later on. And so schools have increased duties, increased requirements for provision without the funding that's supposed to go along with it. So that is a concern, and it's not something that's actually addressed in the white paper.
The other thing to emphasise is that the government is keen to fund things first before they change the law. So they are, in effect, rather than stress testing the system, they are filling, or apparently going to be flooding the system with funding and more support. And then they will see, how do we then change the law in a more kind of granular level, on a kind of more detailed level after that. So they've suggested proposals to various bits of the law, but they haven't yet given the detail of exactly what they will change. So, for example, what they will amend in the Children and Families Act, apart from a couple of key details we'll come to. And so the short answer is that they're putting in that funding first before the law is changing, in order to see how that impacts the system. And many of us, many of people who we speak to, have been advocating for funding to make the system work. The difference is that we have been saying that the funding needed to be put into place to put in place the provision that was in the HCPs, and that wasn't then happening. And many have been saying that the issue was that the Children and Families Act didn't need to change at all. The issue was about understanding the law and actually doing what the law said and having enough funding to be able to do what the law said. And many people were saying if it wasn't broken, don't fix it. But we have what we have. And so we'll see this large funding injection first and right away. And we'll see a training budget as well for schools that we'll be putting right away. There have been a number of different MPs introducing bills in respect to teacher training already in relation to SEND over the last couple of months, or even years if we go back to sort of some of the work that was being done. So we will see that. Whether there is going to be enough time for teachers to do this training alongside all of the other significant training they have to do across all areas, safeguarding the academic side of what they do as well, we shall see. I know that certain schools are concerned about the time that they will literally have to be able to do this work.
Yeah, and I think the other point is whether there are enough teachers. So the white paper talks about 6,000 more teachers coming into education, but teacher retention has been dropping, and we know that we've lost more teachers than they're now going to replace, which is not dissimilar to the police forces, when a significant number of police officers left the force and they weren't replaced, and then the numbers that came back in were sort of cited as this great thing, and we were still sort of 3/4 less than we had. So I think it's going to be really interesting, and I say that sort of in inverted commas, to see how this then will manifest on the ground as that money goes in.
No, definitely agree with that. So there's new language, although it feels familiar for anyone who was in special educational needs work prior to 2014, of targeted plus, and specialist. And so targeted, comes from this idea that targeted support will be for common and ongoing occurring needs, which can't be met just by that universal offer. So again, there's this expectation that the universal will meet most children's needs. That apparently is going to be designed in consultation with parents, that they say will include things like small group interventions, pre-teaching, and so on. Those on targeted would have an ISP, an individual support plan. I'll come back to what that means. And those plans are then drawn up by schools. These are then going to be interactive, accessible, and available in a digital format, these ISPs, but it's unclear exactly what legal status they will have. On the radio this morning on Women's Hour, the school standards minister said that they would have legal footing, but it was very difficult to understand when pressed what is meant by that and whether there will be any mechanism to actually challenge it legally other than through appealing to the governors or some other mechanism through the school at first instance. And so that's what an ISP would look like in terms of what it would be for targeted. Targeted plus, not particularly clear how different this would be. The suggestion is that this would be drawing on the new experts at hand service, which would aim to improve access to education and healthcare professionals. And this might also be those who access inclusion bases or support bases within a school. It might include children who need to access alternative provision. It could also include time-limited support in a specialist setting as well. So short-term placements might be dealt with through targeted plus level supports. Then we've got specialist. So the proposal is that this would see mainstream and specialist settings working in partnership for those with complex needs. I don't understand how that would work, but this idea that they would be provisions set out in one of the new nationally defined specialist provision packages, and that then support could be delivered through a specialist base, and those sorts of things should be available. And then only in the future, it said that only children who would need the support would be entitled to an EHCP, and they would also have an ISP. So you'd have an ISP and an EHCP. The nationally defined specialist provision packages have also come under some scrutiny in the last 24 hours as well. But it's this idea that these will be evidence-based ideas of what is right for children with particular categories of need. Anyone in this field who spends their day arguing about the evidence base for direct speech and language therapy versus an embedded approach to speech and language therapy may find that there is a lot of disputes about what is the right type of provision to be in a specialist provision package for particular needs. That's the whole point of what we argue about a lot of the time in the tribunal. But without that mechanism to deal with those sorts of disputes for the vast majority of children, the question is, how will we know properly what is right within a specialist provision package? It is not so clear. So taking from the easy read, because it is helpful, to really be clear about this. So the idea is that more children in mainstream places will not need an HCP to get extra help. They will have an individual support plan instead that will say what support the child needs day to day, and then individual support plans apparently will allow children to get support they need more quickly and will be written by people who know the child best. It says that will mean parents and teachers too. Polly, do you have anything else you want to say about ISPs and
Yes.
the new tiers of support? Because I know you had a view, a lot of people have been saying things about this is similar to school action plus, but I think you had a more nuanced take on that.
Yeah, I think the unfortunate issue here is that the government have chosen to use very similar wording, which has meant people have jumped straight on that and said, well, we had that before 2014. It's just, putting everything back into place that we already had. That's not quite the case. And the reason it's not quite the case is because the ISPs are going to be a statutory document. Now, you can argue actually that we already have that system. Every school has a different name for it. One plans, IEPs. There's already a document there and there's already a requirement, but the white paper seems to be suggesting that it is going to be a bit more than just your current IEP or whatever your school calls it. And it suggests accountability. Now the question becomes, because I think anybody that has spoken to me and tried to drag me off my soapbox will know that accountability is one of my big issues, because I don't think there is enough accountability. And actually the white paper mentions accountability a lot in the context of schools. So it's very much pushing the requirement of putting in place the ISP, which is going to be a requirement for all children with SEND, and putting that in place, making sure that the content of that is accurate and kept up to date, making sure the provision is put in place in line with that ISP. And I think that that's going to be the difference between the old school action plus system and this new targeted system. Is actually, yes, it feels similar, but there is going to be a statutory regime for it in theory. Now, I can imagine schools and head teachers going, well, hang on, how am I going to staff that? How are we supposed to manage all of this new responsibility? And at the moment, the white paper envisages that you will have this injection of cash, you will have these additional people, you will have these experts coming in to experts in hand for targeted plus. All of that will be in your ISPs. So there's sort of a higher level of mandating from the government than the old system, in my view.
But I think the key question remains, how would you be able to challenge an ISP? And I don't
that's
think
a real worry.
In the last one, I don't think that is necessarily clear to people.
No.
And it may well be that because there's going to be these national inclusion standards, that there is clarity about what people should be expecting that is included in these. And it will be more than what is currently set out in the SEND Code of Practice, for example, about an IEP. It may well be a lot more prescriptive about what should be expected in there, in the same way that it's relatively prescriptive in an EHCP, perhaps, yet without the same accountability mechanism through the first tier tribunal. There is going to be a uniformity of both ISPs and EHCPs, we are told, so plans being digitised. And by that, really, I mean, I don't think anyone still does pen and paper versions of these things, but anyone working or has ever experienced an EHCP from more than one local authority will know how different they can look between different local authorities. And of course, they look different between different schools. So the idea that there will be a specific template, I mean, this is something we've been asking for years, but a specific template for these documents could be very helpful. But one size fits all may well be another question that is raised.
Yeah, and I think what's going to really trouble parents about this, and I completely get it, is that when you have EHCPs, if you want to challenge them, you go to the tribunal, you have a specialist panel, you have your specialist judge, your 1 or 2 wing panel members who are educationalists or therapists, and have been around the block when it comes to SEND and to provision, and you end up with an EHCP that has all of that specificity in it that you need for that young person. And I think what is going to trouble parents is twofold. Firstly is, are schools going to be able to give these plans the specificity they need? And secondly, they're currently, it's quite clear from my reading, and I think Alice, you'll agree, that the tribunal is not intended to be part of the ISP process. That may change, but that's certainly not what's currently cited. So the plan is most definitely to move away from tribunal challenge for ISP. So you will have a lot of children and very concerned parents saying, well, you know, my child's got this document, but actually, how am I going to be able to challenge it? The answer is, at the moment, we don't know. And I get the points that I've seen on specificity and quantification of provision. And I think that that's a big gap at the moment in the white paper and in our understanding.
So what is the plan with EHCPs? I mean, for many parents, they will get an EHCP, they work extremely hard to get an EHCP for their child. And then it's really difficult because often that EHCP hasn't got enforceable provision in it, and they need to then challenge that again at the First Tribunal. And at the moment, we're seeing waiting times for EHCP content appeals, where if you were to register one today, you won't get a hearing until spring in 2027. And you might really need a school immediately, and your child's out of school for years. We see that every day in our practice. And I think part of the thrust of what's being changed is this idea that children should not have to wait that long for support. And there is an idea that the government have that there are too many children with EHCPs, we need less. And many people in this room will have very, very strong views about that being the right approach or not. But the aim is to halve the number of children with EHCPs on the basis that children shouldn't need them if there is better support in schools. This is the aim. And also, there will be a bit of a different way around of dealing with these. So EHCPs are going to be created after somehow there's a specialist package designed and after placement decisions have been made rather than before. And this is a bit difficult for us as practitioners who've been working in the CFA framework, Children and Families Act framework, for 10 years to imagine. But it's this idea of working that way round instead. That sounds interesting to me. As I've already indicated, there will also be digitisation and uniformity, perhaps the end of the dreaded working document, which can be very difficult for practitioners to and parents to have to get their heads around, and certainly tribunals don't enjoy them very much, and they're trying to clamp down on the length of EHCPs in tribunal hearings in the first place. But we do know that is one of the main aims of these reforms. The idea of then being able to transition and getting additional support in mainstream and then transition to an ISP instead. The way in which the government seems to be expecting to work on this is that there will still be there may well still be an assessment process about whether or not you require an EHCP or not, and not reaching the threshold will still allow you to challenge that at the tribunal. And so that's currently the way in which it works if you don't meet the threshold. And we also have seen that the aim is for those changes not to take effect right away at all. So all children, depends on we're reading it in different ways in different sources of the government's documents. But as Polly said, so all children in arguably year 3 or above would retain their existing EHCP until at least age 16. But there is also this big question about reviewing between primary and secondary. On the other hand, we already have a review mechanism every year. It's called the annual review. We already have phase transfers that already exists. So a lot of people have been very worried about this reassessment at that transition between primary and secondary. And again, it was all Women's Hour this morning, but we do technically already have a review mechanism that generally is happening at that point, because mainly children move schools, and that can usually trigger a question about the sort of provision that a young person needs in a different setting, usually. But of course, that is not often the reality. Was there anything else you want to say on this? Go on.
Yeah, I was just going to say, I think the word reassessment is what's causing concern from what I've seen and heard. So at the moment, quite right, we have the phase transfer review, we have annual reviews, but the white paper very clearly says reassessment. And for some parents, where they have fought to get their children assessed in the first place, to get that EHCP and to get that support, the prospect of a full reassessment when it's not necessary, I think, is what is most concerning. And it's the language, it's the semantics here. So rather than just reviewing the outcomes, the provision, all of that, it's actually looking at, does the child still need this level of provision at all, and we will reassess them completely. I think that's what is causing, or certainly the temperature check I've had them going through documents, is what's causing the concern at the moment.
And I think the reason, just to be clear, why I had thought that there might be a reduction in the need for a working document, because we've had a question, I think it's important to raise it at this point, is because if there's better templates and there's higher standards of what we should be expecting in these documents, then arguably there's a need for fewer amendments, hypothetically, to a EHCP, because it's better in the first place. This feels very aspirational to me. We already know what the obligations are about what legally an EHCP should say, yet we're in tribunal every day saying that it hasn't been done properly. So even though there are those rules already. So it could reduce, I think, the complexity of the working document process, I would hope, but perhaps not end it altogether. So on a side of it, lots of people have been thinking about, what does this mean for special schools? There's a huge emphasis on mainstream schools. The presumption of mainstream is really being emphasised through these reforms. And I think there's a couple of different elements of this. There's firstly the fact that obviously a lot of special schools are things that mainstream schools want to draw upon for their expertise and outreach and perhaps short-term placement. So that the government is emphasising that for a lot of young people to stay in mainstream, they need to draw on the advice of those who are providing outreach supports. Okay. We also have an expectation, I think, of improving the standards across the special schools network, perhaps because of a really real variability, maybe because there's been quite a lot of schools that have been created to meet the needs of children who aren't having their needs met in ordinary mainstream schools and academy schools, but that aren't special school children, is often the way in which parents put it to me. And they need to create a very bespoke sort of offering to meet the needs of a particular cohort of young people. But I think because there's quite a lot of new schools, new special schools, new alternative providers. So the government's going to do a separate consultation to try and improve standards across the sector. And we'll say that you can't register as an independent school, special school specifically, without meeting these new standards. And you can't receive state funding without meeting these standards. But I think there's a real question mark about how do you get a special school named on your plan? And is there going to be a default presumption of it being actually much more presumption of mainstream or mainstream unit than we ever seen before? And then the third thing that's important here is I think it's fair to say that there is a concern about the amount that some special schools might charge, hypothetically, but I think that's causing quite a lot of worry in the independent special sector, lots of those schools are highly specialist and really experienced in meeting the needs of those children. But I think we are seeing a bit of a crackdown on that and a criticism of what they can produce in terms of output. And I think it may be that there is a presumption of independent special schools may not be focusing so heavily on attainment results in comparison to the sorts of skills that are really very, very important that might be being developed in the independent special school sector, life skills and so on. But there is definitely worry that we are seeing across the independent special school sector in the last 24 hours, and no real clarity on how the special school sector will be funded. There's an expectation of outreach, short-term placement support, higher standards expected, but it is not necessarily clear how those settings, particularly independent special sector schools, will be funded at all. Whether that training, whether that expertise, whether the ISD requirement applies, it's not clear.
Yeah.
And independent schools, full stop, sorry, are not featured very heavily at all in the paper.
I was just going to pick up on that point, Alice. In fact, you sent me a message yesterday saying, have they forgotten about independent schools? Do they not exist? Because they really don't feature in there. But I think we'll come on to how the tribunal might feature later on. But one of the big questions for parents is going to be where there are a shortage of state-maintained special schools, and the specialism of these independent sector schools are going to meet the needs of their child, who may fall into a definition yet to be handed out to us about complex and severe. whether they're going to be able to get those special schools named. And I think that's a real concern, not least because although complex and severe it is carved out as specialist provision, it's also quite clear in the white paper that complex and severe EHCP young people can still be in mainstream school. So we really don't know what is going to be meant by complex and severe and what this definition will be. But how that then feeds into getting a school named in an EHCP and thereafter challenging that in tribunal will be a really interesting point to see made out once we get a bit more information, because we could face a situation where parents are struggling to find any special schools and also meeting barriers to having independent special schools named.
And I think certainly a lot of the press about it has been raising worries across any parent, lots of parent communities, of any parent with a child with autism or ADHD is very worried that they're not going to be seen as complex or severe. Which I think that there needs to be some real reassurance about. So
yeah, I think just to pick up on that point before we move on, we also, if you have a look at the specialist provision packages and the document is very much a draft document, and we were quite surprised at how draft it is at the moment. But one of the things that we were discussing is the fact that needs are being broken down into almost sub needs, and particularly around SEMH, and that seems to be impacting ASD and ADHD in particular, which is a concern in the community. Because one of the concerns that we see over and over again on feeds and in the media and on articles is that this is essentially an attempt to reduce the number of plans for autistic children and those with ADHD, so neurodivergent young people. So SEMH, for example, is carved out in two ways: externalizing behaviours. So those young people who have behaviours which might be for example, aggressive or might result in eloping or however that manifests. And then young people who have intrinsic behaviours around SEMH, so are seen to be withdrawing. Interestingly, the definition currently cites ASD and ADHD for externalising behaviours, but for internalising SEMH, only ASD, which puts a massive question mark over whether, for example, ADHD might no longer sit in that category. And I think this is where we're seeing a lot of concern, particularly for parents. How are you going to define my child's needs? That, you know, they don't just fit in this box that you're telling us. But that is also going to then lead to how do we get them into the right school if they don't fit into your box?
Understandably, there's a lot about accountability. And so I think the answer to that has been about new standards being introduced that will set evidence-based guidance for what is going to be in the universal offer, what is targeted plus, what specialists should look like. And that's going to be guided, we're told, by an independent expert panel. We don't know who that's going to be at all. I think that I've seen certainly various takes that are concerned about various different types of approaches and perhaps more behaviouralist approaches. Some people really get that. Some people think it's the right way of doing things. There is definitely a debate to be had about what is the right thing, what should the evidence base be focusing on. But we do know, again, as practitioners, that people argue every day about what is the right approach. And we've had even things that are seen as sort of standard mainstream things like zones of regulation. We hear alternative takes on that later down the line from young people who say, I hated it. Okay, it's really interesting to see that. And there's a lot of assumptions about like what we often describe as off-the-shelf strategies to help children and young people that might work for quite a lot of young people, but not right for all young people with special educational needs. And I think that I'm hoping that we'll see some clarity on what is meant by this independent expert panel. So I think some people are going to be a bit dubious about it. But at the same time, standards, and the standards being raised across the sector is probably going to be a sensible thing. We'll also see school inclusion duties as part of a school inclusion duty, which will mean that schools have got to be proactive in planning the support that they provide through this new duty. So an annual inclusion strategy. This is not just like a SEN information report that we've got at the moment, but Ofsted is going to be looking at holding leaders accountable for embedding inclusion in its setting, you know, looking at how staff might be trained, looking at the inclusion bases that a school has got, making those things public, accountable. So it's all very much on the individual schools to do. The Equality Act currently isn't going anywhere, and so I think that there are going to be much higher expectations of what a school should be doing to support a young person with a disability who is protected under the Equality Act. Not all children with special educational needs will be disabled for the purposes of the Equality Act, but certainly for the most part, children with EHCPs are very, very, very likely to be disabled for the purposes of the Equality Act. Professor Struggles being an example where you wouldn't be. And so why I say there will be a clear impact is because, of course, where you have questions about how reasonable an adjustment is that adjustment reasonable? If there's more money to do that reasonable adjustment, then the adjustment is more likely to be argued that it should be made. So whereas in the past, you could, as a school, do training on PDA, for example, there's now funding to do it. So it's a failure to make reasonable adjustments not to, perhaps. There's also other obligations under the Equality Act under Section 15 of the Equality Act to make sure that you act proportionately in relation to particular decisions. So, for example, if you were to choose to permanently exclude a young person because of behaviour arising in consequence of their disability, for example, if they are acting in a way that is breaching the school's behaviour rules, in a way that may well be a manifestation of their disability in some way, at least in part, that school is going to be expected now to have done even more prior to that decision to permanently exclude, and to have exhausted a lot more options than they may well currently have it. And schools are able to and do frequently defend their decisions based on, we don't have LA support, we don't have an EP, we don't have assault, we don't have alternative provision, we don't have any funding, we don't have any more people, we don't have any staff. That may well change. So we'll see, I think, a big impact on how the Equality Act is currently being litigated. Of course, first the tribunal has an Equality Act dimension. They deal with only in the hundreds of cases at the moment in the First Tier Tribunal on Equality Act cases involving disability discrimination in schools. I guarantee that with these changes, that number will rise significantly.
Yeah, I agree.
So we'll see. And we'll also see, yeah, as I said, Ofsted will be a part of inspecting this, not in terms of individual investigations into children, but certainly a kind of accountability that we're seeing for example, off-rolling and so on as well. I think we'll see in the Equality Act as well. We may well see featuring in Ofsted inspection reports. Said code of practice will be updated, obviously, but I'm not sure, it's not clear exactly when or how it will happen. The existing SEND code of practice is what is in force now, but I think the DfE is focusing on the idea that the code of practice will increase clarity and accountability and to signpost for things like government training and so on. There are these new areas of development. So, for example, at the moment we've got sensory and physical communication, interaction, social, emotional, mental health and cognition and learning. There's a suggestion that this is broadened out to include executive functioning in more detail, I think, but everything else looks pretty much the same. So sensory is properly understood, perhaps as a separate thing to motor and fine motor, gross motor skills. Interesting to see executive functioning put there. And mental health support as well is emphasised, but there seems to be a reliance on health partners providing quite a lot of that support. I mean, I'm sure in the room I have quite a lot of views on the ability for local health to be able to provide that support in reality to children with mental health difficulties at the moment, and there doesn't seem to be, I don't know, Polly, if you've seen any suggestion of increased funding to camps.
No, I haven't seen it anywhere. I mean, I think this is the problem. We've got this initial document. I think we will see further information coming out, perhaps about funding for CAMS in the context of education, perhaps, but at the moment, no, I haven't seen anything specific.
But another, I suppose, positive is this idea of expecting greater multidisciplinary, multi-agency working. We've seen a big emphasis on this in safeguarding expectations across local authorities and schools and other partners, police partners and so on. So I think you can see the same idea of information sharing, collaboration between schools and between different organisations, the local authority with the ICP as well. What this will mean for cases where a young person also has complex health needs in conjunction with complex special educational needs is not clear. For example, if you have an extended trial at the moment, extended appeal, sorry, that would include amendments to Section G of a plan to include healthcare provision, it's not really a focus in the new proposals, perhaps because it is very much understood to be part of the complex side of things, but it's not clear. Likewise, social care, I just laugh because it's just not in the paper in very much detail at all. So we have this idea of greater collaboration, but not any real clarity about exactly what that role will be. But I suspect we will see a bit more clarity about what those local groups and SEND clusters should look like, which I'm hopeful about, more information sharing and so on. Paul, is there anything else you want to say, sorry, on the idea of local working between schools, between local authority partners?
Yeah, only just to acknowledge that actually I appreciate a lot of schools are already doing this. So not just within their own academy trust, for example, but in local areas, you do get collaboration between different schools. They share knowledge, share ideas, meet regularly. So I think for some schools, they'll be looking at this thinking, well, we already do this. So why is it going into the white paper? And I guess the answer is, if you're doing it and it's best practice and not everybody's doing it, then that's why there's a nod to now bringing these clusters in. But if you are already doing it, it's just more of the same for you. But I agree with what Alice said. I think it's just the increase in accountability, and it is focusing very much on schools being responsible for a lot more than they are now, which is why they're looking at the local SEND clusters for knowledge sharing.
Yeah. And I think it's fair to say that there may well be cases where a young person reaches the threshold of needing an EHCP because they might have complex health and social care needs. And it might be that on its own, SEN might not necessarily be what's going to reach that threshold. But where does that leave that young person with an ISP? That it's not IEP, so perhaps the S is meant to encapsulate health and social care related support. But I mean, schools are already doing a lot. They are healthcare professionals or social workers. So
yeah, and I think
I see.
Well, it raises questions as well, doesn't it, around section 21, subsection 5, educates or trains. I mean, if we're talking about health or social care, and that's not going to be covered by ISPs, but we do have provision at the moment within the Children and Families Act to include in educational provisions social care and health that educates or trains. This at the moment is not addressed clearly at all in the white paper, and I think that's actually a glaring omission.
Yeah, because the buck will be passed to schools to sort it out. There's twofold things that have changed. There's a strong emphasis in the new paper on schools having a good complaints process so that disagreements can be resolved faster and more collaboratively, reducing the need for an appeal to the SEND tribunal. There's also a strong emphasis on mediation as well as an alternative to challenging things at the tribunal. They stopped short of compulsory mediation, which I thought was interesting, because there was certainly being mooted over the last couple of years, and I know that several people were challenging that, but there's an emphasis certainly on it. But the thrust is to avoid the tribunal, and so we will see, I am sure, a greater level of complaints towards schools about the contents of these plans for children and young people, I think. So they're going to need to be equipped to deal with it. But the DfE has pledged to work with schools to strengthen complaints processes and with some sort of digital solution to handling those complaints. Whether that is an outsourced complaints system, which acts like the tribunal, we will have to see. But there probably, I can imagine that there might be some admin burden that might be alleviated, potentially, or maybe even using AI to be able to deal with complaints. I'm not sure that many parents would be that reassured by that. Anyway, the first tier tribunal, this will remain in place. It hasn't been abolished, despite the kite flying about 6 months ago that it was going to be abolished altogether. It is strongly emphasised, however, to be a last resort, and I think that the threshold for a young person being eligible for an EHCP will change over time because of the fact that the expectation of what is ordinarily available in mainstream schools will be better or increased in principle. So I think we are going to see fewer first tier tribunal cases for sure, at least in EHCP cases. But the proposals have also been talking about changing particular aspects of the Children and Families Act as well. So in particular, those will be familiar with cases involving Section I, where a school is then named in an EHCP the school then has an obligation to admit that child, and then the local authority has the duty to secure the provisions set out in Section F of that plan. On the day-to-day level, that's then delivered by the school. In the Children and Families Act, there is, depending on what particular type of school it is, a presumption that a parental preference for a school will be named, unless one of the exceptions in Section 39 of the Children and Families Act is made out. And what I mean by that is there an exception that it shouldn't be named because it's not suitable to meet the age, ability, aptitude, or special educational needs of that child? Is it instead going to be an inefficient use of resources for that child to have a place at that particular school? Or might it be incompatible with the efficient education of others? Those are the current exceptions in Section 39, and these are often argued about every day in the First Year Tribunal. And a lot of that does tend to really come down to money and space in particular schools. There's a suggestion that the Section 39 exceptions will be amended to include, in effect, a much clearer value for money argument, not just that it would be an inefficient use of resources, but you also have to prove that the value for money for a child to be able to be placed at that setting. But equally, a bit more of a black and white, it's full, being a way in which a school can avoid being named in an EHCP as well. But we also know that the First Year Tribunal power to name a school is also being removed in principle. That is not currently the law. You can currently go to a First Year Tribunal, get a school named in an EHCP. Do not panic about that aspect. But the proposal is that the tribunal will no longer have the power to name a school in Section I of the EHCP, and the parental preference is then going to be given less weight. So the mechanism is then set out here. They read in the consultation process. So you'll see in this, so does the child meet the threshold for an EHCP or not? They must consider resolution through mediation. If they don't have mediation, they then go to the tribunal. And so then there might be a question about threshold, which is going to be dealt with on the left-hand side. So tribunal can make a binding decision that the child or young person is eligible for a specific specialist provision package or not, and the tribunal alternatively will uphold the LA decision. But then in relation to placement decisions, so you might already you might already be found to be eligible for a specific specialist provision package. But the tribunal is then asked to make a decision not to name a particular place, but to review, in effect, the local authority's decision on a particular placement. And if they find that that is unreasonable, to borrow the language from judicial review, they can then quash it and require the local authority to retake the decision. Alternatively, the tribunal can just uphold the local authority's decision. That is a big change to how Section I is currently dealt with. Section I at the moment is dealt with by a specialist expert tribunal who is able to decide which school is suitable to meet the child's needs, and if both schools are suitable, to then go through the exercise of deciding whether or not, under the Children and Families Act, any of those exceptions are made out. And then there's also the question of Section 9 of the Education Act about whether or not there would be unreasonable public expenditure, which allows for many more additional benefits of that placement to be weighed into the balance, to allow, on the face of it, more expensive placements than what the local authority has been proposing to be named in Section 9 of the EHCP. This is a big change, I think, and it's a really unusual thing, I think, to draw on what we see in exclusions law to then apply that to the First Year Tribunal in relation to placement. Holly, what do you think about this proposed mechanism?
Yeah, I have huge concerns about this. I think it's one of the points for me that is most concerning, because when the law changed in exclusions, and we're talking 2012, one of the big changes was that the independent appeals panel became the independent review panel, and the review panel can quash a decision of a governing body, send it back for reconsideration. The governing body can look at it and go, well, we've reconsidered it and we're still making the same decision. And where does that leave children who have been permanently excluded? My concern here is that we are walking into a similar situation where the tribunals say, we're quashing your decision, local authority, you need to reconsider it. it goes back to the local authority for reconsideration, and they say, well, we've looked at it and we've come to the same conclusion. So where does that leave us? Is that going to increase judicial review? There are then question marks over, who has the right to judicial review? Is there going to be funding available for that? And so it's one of the most troubling things for me, because the Equality and Human Rights Commission has already made comment about whether it's right that no independent body ever looks at an exclusion and can reinstate a child, apart from send tribunal with additional needs, but that's separate. But I think we're potentially facing the same situation here. When does anybody independent look at this and say, local authority, this is the wrong decision, and this is where the child should go? That's the key.
I think also, concerningly, this doesn't appear to be a feature of the consultation. So if anyone does have concerns about this, they're going to have to shoehorn any concerns about it in another section of the consultation response. What is obviously missing from this, and is a huge proportion of the work that I currently do and I specialise in, is anything about children who are not in school and who cannot attend school. So many in the room will be familiar with language about children who are accessing education otherwise than in school packages. There is no mention of them in this proposal. And so what that means for section 61 of the Children and Families Act, where the tribunal at the moment looks at questions of whether or not it would be inappropriate for provision to be delivered in a school that allows a young person with special educational needs to access education outside of the ordinary confines of a school, whether a special school or a mainstream school. It is not clear how that category of young person would be dealt with. And it may well be that there is simply an increased expectation that that child will attend school because there is more resourcing in the mainstream school sector. But we don't know, because it doesn't say. But I think there's certainly going to be quite a lot of work for public lawyers in respect of judicial review type decisions. I think we'll also have potentially some technical questions being asked about how funding works as well, where funding is going to come from. I've seen news of, for example, free training for educational psychologists. We might find that the current educational psychologists who are working tribunal are reallocated and working more directly with schools, perhaps to improve processes within the schools on the ground. But certainly there is an expectation that we will see a streamlining of current school funding landscape. But I know that many parents will tell me that they aren't really clear what is happening to the money that is attached to their children's provision. Polly, I don't know if you had anything else to say from a funding perspective.
No, I think the point you made about the lack of understanding of where funding goes has always been a massive issue. When local authorities are saying, well, we've paid the school X amount, and the school is saying, well, we've received it, but it's gone because provisions Y. I think clarity is absolutely necessary in this process.
So, I mean, I think that's probably going to come in the next couple of weeks. We'll see probably the DfE talking about ring fencing things and what their funding formulas might look like. I don't know. We'll see. Other new bits, experts at hand, the new proposed initiative, local inclusion partnerships, and this phrase about strengthened mainstream capacity as well. So you'll see those things mentioned too.
I think just to pick up on the experts at hand, one of the concerns that I share with a lot of other people is, well, it's all very well saying that Targeted Plus will give access to experts at hand, and that you'll be able to, as a school, contact your SALT or contact your OT. There is a finite amount, and part of the pushback as practitioners that we've seen is, well, there isn't an available SALT, there isn't an available OT. I mean, I've experienced situations where my clients have applied for a needs assessment and been told, yes, we will do a needs assessment, but we don't have an EP, so you'll have to wait 12 months. That kind of rhetoric that has been a concern since day one, really. Is that going to change just because you name the service something different? There is still a finite resource here. And I think one of the biggest issues missing is how we're actually going to find all of these additional experts, where they're going to come from. Putting the funding aside, you actually do need people to fund. And I think that there isn't a clear answer to how we're going to find all of these experts that will be able to support this Targeted Plus expert at hand.
So I thought it would be helpful to sort of talk about, well, why is the government deciding to change it in this way? The concerns about funding. They've wanted to do a big cash injection into this particular sector, really concerned about delays. They They say that they've spoken to lots of children and families and charities and local authorities. They talk about being inundated with requests for EHCPs, the delays in the tribunal system, not getting the support, the EHCP not being worth the money that it's paid for, or challenged, the amount of effort that it's done to challenge it in the tribunal. We know that there are problems, I think is the point that the DfE is reflecting. Concerns with compliance, concerns with inequality of provision across the country, the idea that there isn't a national standard across what arguably is meant to have been in the code of practice, but in reality there isn't equality of provision across the country. The DfE also starts with a lot of very negative views about how children are viewing school at the moment, with statistics that they have relied upon. I appreciate people are trying to get behind those stats, but certainly saying that there is a lot of negativity around school experiences and children who've been through a huge amount through the pandemic, as well as the rise of tech and AI and everything that comes with those sorts of difficult experiences, both positive and negative. So we have a lot of negativity about the school experience from children and young people, we're told. But on that, we have quite an aspirational move to make things better, we're told, for children and young people. That seems to be the why. I've indicated that there are quite a lot of categories of things that haven't been mentioned. So, as I said, independent mainstream schools, children in need of EOTIS, those unable to go to school, those missing education as well. There's a kind of category of children and young people who don't easily fit into mainstream schools, maintain mainstream schools with children with 30 people in a class, but will do very well in a more kind of independent mainstream school type setting with 12 or fewer, 16 or fewer pupils, a much more smaller, nurturing, quieter environment. Not really that clear what will happen to those young people. They probably won't be deemed as complex, but they still will fall in the gaps between mainstream and specialist, probably with an argument that those children and young people could be dealt with in the mainstream hubs or units attached. But we again have question marks about the evidence base there. I've also seen various professionals talk about the absence of particular disorders and diagnoses, EBSA, emotional based school avoidance there, as well as developmental language disorder. I've seen some concerns about particular things being missing. So lots of concerns. I appreciate we've been quite negative, but Special Needs Jungle, there's a link here to really keep an eye on what they're doing. They're doing quite a lot alongside many other organisations like IPSIA and so on, about what the rights are and what rights that are being, in their view, stripped away. Concerns, as Polly said, about experts. Do they grow on trees? No. Lack of enforceability. Concerns about end of the tribunal or reduction in the powers of the tribunal, yet increase in the Equality Act claims and judicial review increase. There's quite a lot of concerns here. What does it mean in terms of reassessment rather than a review at key transition points, in terms of already argued for and achieved provision? Concerns about particular categories of children, risk of reduced support for some of them. Mainstreaming without adequate resource. What does it mean? Resource bases, evidence base for those. And then there's big impact on parental rights and school choice, which probably I know you wanted to speak about in some detail about human rights implications. I would also add there's nothing on school transport in this I've seen, although I've seen certainly a large suggestion of means testing school transport, which I think will be the proposed solution at the moment. Go.
Yeah, just to pick up on expert reports as well, because I know we were asked a question about it in advance too. There isn't anything in the white paper which addresses whether independently commissioned reports will be accepted, and whether there will be an expectation on schools, for example, to commission reports themselves, or whether parent commissioned reports can be taken into account in ISPs. That information, it just isn't in the white paper yet. So there is a big question mark on how much parental involvement there will be, albeit that the thrust of the white paper seems to be we want parents involved. There is a question mark over how much parental involvement there will be in producing things like ISPs in terms of obtaining independent expert reports. There's a concern as well about human rights implications. So we've named Article 14, prohibition to discrimination. So there is a real concern here that there will be potentially indirect discrimination of young people of certain categories, for example, or there may well be wider concerns around discrimination more generally of particularly, I think we might see ASD, ADHD concerns in particular if they're not very, very carefully managed around the complex and severe. I know that some people are worried essentially this process is about removing that group almost entirely from EHCPs. And whilst I don't agree necessarily with that, I think that there is an element behind it as well. Article 2, Protocol 1, right to education. If we're talking about restricting young people's rights to education, parents' rights to particular schools, is that going to interplay with an Article 2, Protocol 1 challenge? And finally, Article 6, so a right to a fair hearing. And this one is a concern I have, which feeds into, again, the exclusions legislation and now potentially tribunal legislation, where actually, so firstly, how are the complaints or challenges of an ISP going to be dealt with? Is a parent going to be able to challenge those in a useful way? But also in terms of tribunal, is there going to be an opportunity for a fair hearing around concerns about schools being named in particular? We don't know, but it's something certainly as practitioners we'll be keeping our eye on, are any human rights challenges that may be popping up.
So how it's going to be done in terms of legislation, it's not entirely clear. It could be through the Child and Wellbeing in Schools Bill. That'll probably be the functional way in which quite a lot of the funding decisions will be done in terms of the immediate work. In terms of changes to the Children and Families Act itself, I think because of the fact of the government wanting to put funding in place first, see how it works, see how issues might manifest in different areas, I think that they will probably want the Children and Wellbeing in School Bill not to carry on in draft format for the next 5 years. And so we may all see different, and I think we probably will see separate draft legislation in respect of those new specialist school standards and the kind of roles of schools in relation to national inclusion standards. They could be under the Children Wellbeing Schools Bill. I think, like the independent school standards, they may well be separate. We shall see. But what are the positives? I appreciate many hundreds of you here tonight. I've got lots of negative concerns, but I think there's some real positives in terms of teacher training. So 200 million pounds worth of funding in new training, we're told. The idea of sharing expertise and resources between different professionals, sharing ideas to help meet the needs of young people. The amount of information sharing that's done usually in parent support groups, for example, is amazing. And so we may well see quite a lot more of that. But on the ground in schools as well, between schools and between local authorities and schools. It's also staggered. It's not being done overnight, right away, without thinking about the ramifications. It is certainly a staggered, staged plan that we're seeing. Arguably, with a question mark, there's a question about, is this going to be fairer for more children and young people across the country? Potentially, that will be so. And also, importantly, as a consultation, it's not set in stone, and there are opportunities to participate in this, and we will see a lot of useful conversations, I think, from various organisations about what should be done now. Polly, did you want to run through the time frame that's coming up?
Yeah, so Sure. So the public consultation that was launched yesterday alongside the white paper will now run until the 18th of May. And I think that's a really important opportunity for anybody who's here. If you have something to say, now is the time to say it within the confines of that consultation. Get those links to consultations out into your network through LinkedIn, through your mailing list, and feed into organisations like Special Needs Jungle and IPSI, who do a lot of work and also very good work around lobbying in these situations. So I think it's really important that we are listening to each other and making sure that everybody who wants an opportunity to engage in that consultation has it. So as I say, get those links out on your networks and engage with it. There will be policy refinement and listening sessions in mid-2026 once they have the consultation response. What a listening session is going to look like, we may all have our views about that, but those those sessions will be coming up. And again, let's keep our ear to the ground, you know what I mean. Drafting of legislation looks like it's going to take place sometime in late 26, 27, with parliamentary scrutiny 27, 28, and a phased implementation across 2028 to 35. But as we said earlier, the first we will see of this coming through is around about 2029, and there won't be any changes to support given to EHCPs to begin by EHCPs will begin before September 2030. So the key is, as we said right at the start, nothing is changing immediately. Yes, there's more money going in earlier, but nothing for the purposes of our young people who have EHCPs currently is changing yet. And so it's business as usual on the EHCPs, appeals, requests for assessment, all of that continues, because we don't expect to see any changes in that support until September 2030.
I think we'll see a lot more conversation, and you may find it's fair to note that this isn't the only area of SEND that is being discussed. So we've got NHS reviews about autism and ADHD diagnoses, Autism Act, Milburn Review. We've also got potentially, although failed puberty blockers trial, there's lots of questions about children and young people and their additional needs at the moment. There'll be a lot of conversations to be had. But so at the moment, it is early in the process. There have been lots of amazing questions. I've tried to answer them all as you have been typing them, as we have been speaking, as we've been going along. If there are any further questions that you have that you would like to be able to email us about, you will be sent a copy of these slides after this session tonight. You will also see us, you can catch us on LinkedIn, and as well as our email addresses will be made available to you after this session. But thank you so much. There have been hundreds of you joining us this evening. Really grateful for those who've shared this within their networks. Good luck, and thank you for all of your support and your listening ears. And I hope we can work together to make things better in this system. Okay.
Absolutely. Thanks very much for coming.
Thank you so much. And thank you so much, Polly. I massively appreciate you coming in and joining me with this
Thank you for inviting me.
seminar tonight.